Family members of a man who died in custody at the Mecklenburg County Detention Center are ready to take leaders to court. They recently filed a complaint against the sheriff, the county, and the jail's former health provider.
On July 6, 2022, 25-year-old Russell Finchman was found unresponsive in his cell. Paramedics attempted CPR but were not successful. Well, the complaint states that Finchman then died of fentanyl intoxication, and it goes on to be able to say that his death was caused by detention officers failing to supervise rounds and then observe inmates known to be vulnerable. Family members are now demanding a jury trial.
We are joined now by Chief Legal Analyst Khalif Rhodes. And Khalif, the inmate took drugs on his own here. Does the family have a case?
Great question. There are so many different claims within this 56-page complaint. Had an opportunity to talk with the attorney, one of the attorneys that's on this case. And so they laid out a number of the things that they plan to seek in here. Specifically, if you're looking at a normal wrongful death claim, not 1983, but a normal wrongful death, your answer of he taking drugs in our state would typically bar someone. Why? Because we have contributory negligence. Unlike most other states, in North Carolina, if you contributed to your own actions, your recovery is completely barred unless you can do something called the last clear chance, which is a high hurdle to overcome. But in this claim, this is a 1983 claim as well, which is just not a new type of claim, but it's just another way that they can get an opportunity to sue. Specifically, if you're acting under color of law, like elected officials or sheriff, if you are a person, the sheriff, that's why they sued the sheriff and everyone underneath him. If you have deprived a person of their constitutional rights, if they have damages, and if they can overcome sovereign immunity, there's a claim there. And so even if I think the wrongful death portion under normal tort law may be problematic, under this 1983 claim, there's an argument there because they listed a couple of things that you may need to be able to list when proving this type of claim. All
right, so suing a jail, though, for the death of an inmate in this particular case, is there really a case here?
The main key is policy, policy, policy. And so if I'm going to sue under 1983, I'm going to point to your own policies and say you failed to follow your policies. So if you look at this claim, they list all the deaths that happened over the last 5 or 6 years. And then they talk about, well, in those instances, did you fail? Have you been notified of your failures? And have you reacted within the time frame like you should have done? So in this case, overcrowding is something that you can talk about, but your normal rounds, if you have a policy that says you're supposed to do, rounds every hour or every half hour, and then we can look at the cameras and show that maybe you only did rounds every 4 or 5 hours. And not saying that happened here, but those are the allegations, that there are a number of times that they did not do the rounds. Within this individual's claim, they talk about missing 1 hour, and during that time frame, he died. So if your policy says you're supposed to have come out every 15 minutes or every half hour, and you failed to do that, well, now that really just not opens the door, it opens it extremely wide for a 1983 claim, and that's what they're alleging here. And so does it have an opportunity to go forward? Because that's the biggest question. Do I think it will be successful? That's something for a judge or trier of fact to determine. But most of these cases are dismissed for something called a 12B6. You failed to state a claim. And 99% of claims are hard to get through that portion. Once you get past the 12B6 motion, now we're saying, okay, where are we at with this claim? I think they get past that because they have stated the claim as a 1983 claim crystal clear.
And also because you see some of these people, I mean, some of the people that have been charged or the suit is against, are they going to stay on this suit moving forward? Because as it goes forward, some of them will drop off during the discovery, right?
Law School 101, you sue everybody involved. I mean, so you got to sue the sheriff because that's the only way you get to the 1983 claim. You sue anyone that works under him, and then you see this other agency, the medical providers. It was a third party, so you got to say that he gave them authorization, and because he gave them authorization, that's why they're in there. You talk about a number of other individuals like innkeepers, a person that doesn't even work for the sheriff's office anymore, not just the RNs, but other people that were detention officers are in this claim, sued on their individual capacity. So there's a couple of folks that probably will fall off, but right now, if I'm suing everybody, and that's what they teach you, and then you try to let the courts determine who can stay or who can't stay.
Okay, but in this case, you talked about vulnerable inmates, and so explain that, and how is that different than an inmate who's saying, you know what, I'm taking drugs while I'm inside jail, and if I die, how do you take accountability?
For this situation, this timing, this person was newly brought into there, already going through medical conditions, and they're saying because you didn't go through the proper steps to ensure that this person got the attention he needed, you failed to do what was already in your own policy. So I think this plays out throughout court. This is going to be a long, drawn-out battle for sure.
Khalif Rhodes, we appreciate your insight. Thank you.